going to share with you here a presentation that was initially prepared actually for some first, second, third year lawyers at a couple of quite large firms. I do a reasonable amount of consulting to large firms and sometimes work with their juniors. So its initial life, before it had RMIT branding associated with the back, was around how they should be writing memos to their bosses internally, what kind of things to think about. And then I've kind of added a layer for the assessment piece for you guys. And largely here, I think it's valuable for you to see that lawyers in the real world are writing memos all the time. So those of you who are already working in the profession will see that, particularly advice memos. A memo is kind of, I think it's a dying art when it comes to clients. I think, you know, the memo is dead, long live the email. But in the profession, you see memorandum of advice and intra-office memos being shared all the time. So I want to share a bit of advice about the real world and a bit of advice about how to get this done so that you can get the best marks that you can for your assignment at the same time. So, first piece of advice, plan it out. Plan it a bit more, get your plan right, revise your plan to plan, and then plan again. There's no one way to do this. There's no one way to organise a memo. You can structure it as suits your purposes. Having said that, I'm going to talk you through a really traditional, standard way of doing it. And unless you've got a good reason to vary from standard, and some of you will, because there are some very gifted writers amongst us, I would stick with the traditional way though, unless your way is going to really add value. Got to be strategic when it comes to marking. Think about your memo when it's finished, and then remember that and if I get some marking help, which I hope to do, two of us are going to read all of them. Well, read half each or whatever I can get away with when it comes to marking help. So now we will do our absolute best to read every one of them really, really carefully. But the easier you make it for the person who is marking your paper to see that you've answered the question, that you've addressed all of the things that are in the marking rubric, that you've put it together in a sensible way, the easier it is for us to have a smile on our face and to give you the big numbers. If we've got to really search to find your conclusion, or search to find how your argument flows, then it's much harder for us to do that. So think about the structure from the point of view of the person who's going to read it. Now we are going to try to be Dennis, okay? So I'm good at being Dennis because I am Dennis and I can't work a photocopier to save my soul. And also I spent a lot of my life supervising junior lawyers, so I am pretty good at reading like a senior partner might read. If I get another academic doing it with me, I have to kind of get into their heads as well a little bit. Another academic will probably be more used to reading academic writing than me. So we get that balance right. So how you structure a memo or any communication in the real world will really depend on what it's for. What is the purpose of your communication? So right now, just think about this assignment. Think about the little fantasy situation we've got. What is it that Dennis is actually asking you to do? Why is he asking you to write him a memo? What is the purpose of this piece of paper? Does anyone want to share what their thoughts are? Why does Dennis want you to write him a memo? What's he going to do once he gets it? Sorry, I need your outdoor voice.
Whether our client has the grant to sue or not?
Yeah, he's going to work out whether or not they've got the right to sue or not, whether a contract exists. But what's he physically going to do next?
Read through and use the information you've already researched and build an argument on top of it.
Yeah, so he's going to use your research. He's probably then going to get on the phone to the client, right? he's going to have that memo in front of him while he's talking to the client. He's going to say, Steve, afraid I've got to tell you you're dreaming. Or he's going to say, Steve, you've got a contract, this is what the next steps are. He probably will do it on the phone. That's what most people would do. These are not huge matters. But the next step might be to write them a letter. So he's taking your research and he'll turn that into a letter or an email to tell them what to do next. So think about it from his point of view. What is it? And this is, it's surprising how often, because you go from uni to then working, how graduates have actually forgotten that when their boss asks for a memo, they actually want it to support making a decision about what to do next. One of the things I love to say to the graduates who work for me, when you're at law school, you can get this 80% right and you'll get a high distinction and your mum will tell the neighbours. You get it 20% wrong when you're working for me, I get sued and you probably lose your job. Like, they're completely different things. So think about it like, oh yeah, I know I really shouldn't say this because I do know that mental wellness is really important and please don't stress. So yeah, think about it from the point of view of what does your reader want to do. Lots of this stuff about communicating as a lawyer is really about making sure that the person you're talking to can listen to what it is you have to say. So framing your language appropriately for your audience makes sense. So those of you who haven't watched The Castle, you should do that first. That should be first on your plan. Think about Dennis. Dennis he's a lawyer, right? He's your boss. You need to respect him. We can assume, despite some of the things you've seen in The Castle, that he understands legal language. You can write to him like a lawyer. You can probably assume that he doesn't actually remember all of the cases like that. Again, when you write a piece of advice or answer a problem at uni, chances are your teacher already knows the answer. I don't spend my money on my employees asking them to solve questions when I already know the answer, right? That's not the point. Like, if I already knew the answer, I would be having more money in my bank account and I don't need you. So you've got to assume that he hasn't recently read all of the cases, but he still needs case support. He needs to know that the law is supporting what is said. The way that you talk to the client might be quite different, because talking about the distinction between an offer and a counter-offer with a client, that's meaningless. Talking about an invitation to treat with a client, unless your client is a lawyer, is probably meaningless. So the structure of your actual memo will depend on all of these things: what the purpose is, what your reader needs, what it is you've been asked to do. It should be really clear, what has Dennis asked you to do? What question has he raised? The nature of the type of issue is involved, what you actually find, the amount of time you have and the scope to do things. So I've said this already, it started in the real world, it's now being used for assessment. So no magic to getting started. But do this, make it look like a memo. Don't just launch right in. If you're using any of the major word processing packages, Word, Google Words or whatever it's called, Pages, any of those things, they come with memo templates. Just go with them. Make sure it's clear. Have a bit of fun with it if you want. Want to know who it's to, who it's from, what your subject matter is. Think about the subject matter. It might not be an obvious thing, but I think of the subject matter as being, this is my highlight when it's on the file. So when I'm looking for something in a year's time, that's the line I'm looking at to try and work out, or the title of the document even, as to what this is about. So think about the subject line that you give this document with your reader in mind. So, do you include a table of contents with it? This is a fairly meaty piece of work. Short answer, it's completely up to you. A table of contents is usually useful if it's a particularly long document. I think once you get to 10 pages, you really want to have some sort of framework at the front that helps your reader know where to look for things. It can also provide a really useful outline. So it gives your reader a really quick sort of model of what the framework of your memorandum is going to be. Quite helpful to markers if it's sort of not obvious as we're reading where things fit in. You can go back and look at the table of contents and know usually if the headings that have been used are good, whether something's been covered or just missed. So it's helpful in that way. My line there, let Bill generate it for you. You are pretty early in your law degrees. If you don't know how to use automatic numbers, to use styles in Word, to automatically create a table of contents, now is a really good time to learn those things. I know most lawyers and most law students think they're too special to know how to use word processing software, but they are the tools of our craft, right? Nobody actually ever questions whether or not Michelangelo knew how to use a paintbrush or not, or what paintbrushes he used. They are just tools, but word processing is one of the tools of the craft. Now, I know there are people in this room who work for lawyers and who see them, they will laugh at the idea of dentists because they know that they work for people who would have no idea how to generate a table of contents or put a footnote in a document or any of those things. I'm seeing the nods. And I hear you. Women of my age are usually the worst. I'm going to stand up for us though, because back in the 80s, if you could type, then they made you type all the time. And one of the ways that we actually made sure that we could become lawyers was by pushing the tech away. Unfortunately, I've never really been able to do it. So yeah, I'm on the I know how to use Word and you've got no excuse side of the conundrum. The reality is you can't get away with that as a young lawyer anymore. The kind of mythology in the practice is, oh, young people are really good with tech. My experience is actually most young people are really crap with tech. You know how to send a Facebook message, but you've got no idea what's under the engine, which is fine for you. Love it. But the reality is you're working in a context where a whole lot of people will expect that you know how to do that. So the better that you get at it early, the less pain it will cause you later on. That would be my advice. Where do we start? Good to start with some sort of background or introduction. Something that describes the context, that sets out briefly what you've been asked to do and why it matters. So what it is that you're leading to. Usually you'll identify the scope of your instructions and what you've been asked to do. Specifically, particularly if this is going out to a client or if you are but one of many minions in the coggy wheels of the law firm that you work for. If you're only looking at one issue and somebody else is looking at something else, be really clear about where you fit in the picture if you know. Brevity is key here. Some would say that including a background or an introduction section is optional. If you are fighting for word limit, make sure that it counts if you have one in there. I say the best way to make sure that you're within the word count is to make every word count. So think about every sentence. Think about whether it adds value and whether it moves the conversation forward. Usually we would write the background or the introduction at the end because it's really the vehicle for pointing your reader to where the important things are. It's sort of a high level summary of where you get to, why it's important and where things are. Facts. It is quite usual, particularly if you have gathered the facts from a range of different sources, to have a summary of the material facts towards the beginning of a memo. You want to summarise everything that's legally relevant. You might, in some cases, find it's easier to include a chart or a diagram or a timeline or something like that if it's important. In the particular scenario you've actually got potentially two different transactions, so you might want to separate them out. Usually chronological order is the best way to do things, but again, make every word count. So make sure that you think about the best way to present the facts to highlight what matters. If there's some disagreement or uncertainty about the facts, you need to say so. So again, if you are reading the facts and making some assumptions about how things fitted together or who people were or what they did or anything really, you need to be explicit about the assumptions that you've made and explain why they matter. Because assumptions, so for example, if you decide to assume that Leia Organa was wearing a red dress for some reason, well, great, awesome, but how does that matter? So, but if you assume that she was insane or under the age of 3, that in fact is an assumption that might actually matter. It might make a difference to her capacity to enter into a contract. Again, if you're going to make an assumption like that, you would want to make it based on something that leads you to think that. Like, you know, her conduct leads me to think blah, blah, blah. Again, doesn't really matter what order you use it in. In this particular case, you can assume that Dennis is the one who's given you all the facts. So Dennis knows everything that's in that document. So repeating what Dennis has told you is not making every word count. Picking out the salient matters from what Dennis has told you to highlight the important things because they're somehow relevant to the issues or the application of the law, or because there is some hole in the facts that you think Dennis, when he makes that phone call after reading your memo, might want to raise with the client, ask for more information. They're the kinds of things that you want to highlight here. But otherwise, if you don't think there's anything there, you can just say, I refer to your email to me of blah, 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 and the facts are set out in there. Too easy, as my son would say. I talked about assumptions just a second ago. There are assumptions as to facts. There might also be assumptions as to some sort of unanswered question. You might have to, if you have to add the assumptions in, make sure that the section that deals with the facts clearly identifies that it's also incorporating some assumptions that you use. Issues. So this is where you set out what the legal questions are that you are going to consider in this memorandum. And the issues themselves provide a kind of guide or a map to the problem that you have. My tongue is in my cheek when I say articulate briefly, clearly, simply, concisely, precisely and accurately. Just, you know, like I said, make every word count. Break down the questions into sub-issues if you need to. Don't try and put it all into one sentence and risk your reader missing the nuance or your precise understanding of what you're doing. I think I said this to some people in this class last week. I've said it to you all. The difference between graduate study and postgraduate study is in a graduate degree, you are required to be able to answer the questions. In postgraduate study, you distinguish yourself by knowing what questions to ask. Good lawyers ask the right questions because ultimately we then do the research to find the answer. The question is probably more important than the answer. You still need to answer the question. I cannot overemphasize that. You really need to answer the question. But what the question really is, that's your job to work that out as well. Think about order. Deal with the most important things first. Use numbering, use signposting, refer to things that you said earlier and later rather than repeating yourself over and over again. So this funny little GIF is an approach that you might find useful. I'm going to have to stand back in the room to remind myself what I've put here, to thinking about planning for these kind of problems. It's just going to keep cycling through. I'm a big fan of just using the post-it notes. I know it's not very environmentally friendly of me, but sometimes there's just so much going on. Another way of doing this is print out the problem and then cut it up. So you've got little bits of what the facts are. Get a big space, your kitchen table, floor in your bedroom, wherever it is, and lay it all out. Get the cases, write down the names of the cases that you think might be relevant. Write down the names of the issues or words that remind you of what the issues are, and then sort them out. Start by getting your facts and ordering your facts chronologically, and then say, okay, which of these issues is relevant to which facts? Where do they link to each other? Put them physically in a space. Now, I'm a very visual learner and a very visual thinker, so this works for me. Others of you will find a list in your Word document, or scribbles on your piece of paper will work equally well. But at the end of the day, one of the things I've really cautioned you against, and the thing is, there are a lot of really clever people in this room and beyond it listening on the tape, who it's never been that hard to just start writing and then you get to the answer. Really challenge you to try not to do it that way this time, because we get very wedded to the raw words that we've put down, and there is a little bit of an art to crafting an advice the way that lawyers use them. So spend a little bit more time planning and thinking about what you really want to see and prioritising what you want to do before you get so wedded to the rules. Can't remember this. It's a misquote anyway. I think it's James Joyce who talks about killing your babies. You know, the sentences that you don't need, and how sometimes you just have to delete them or burn them or something like that. I am misquoting some literary giant, but sometimes we have to do that. One of the things I often recommend to people is if you write something and you read it and you think, yep, that's a pretty good summary of the law, but it hasn't actually moved this. It's not particularly relevant to this. If you read a paragraph or a sentence in your piece and you can't immediately link it to the problem at hand and you think this is just a good summary, great. Cut and paste it into a document, call it exam prep, and have a whole heap of little summary statements about the law with supporting cases. Be really useful to you in an exam. But if it's precise, concise and linked to this problem, keep it in. So, another little psych that I do. One of the things that often people have trouble with is trying to work out what are the priority issues. I use this kind of XY approach. What I do is I look at, once I've identified all of the issues I think I need to deal with, I basically line them up in order from the least complex and the easiest to resolve just based on the facts. So, for example, say the issue, we know in order to have a contract we need to have 2 or more parties. Technically an issue might be, are there potentially 2 or more parties? We immediately know yes, right? So it's such a tiny issue, so easily resolved, we probably don't even need to mention it unless we're completely running out of words. Like nothing turns on, it's never going to be in dispute. So it sits right down in this early part of the matrix. And so once we've got the complexity of the problems on one side, then the next thing we do is we think about how relevant is this issue to solving this problem. If it's complex and nuanced and it's really super relevant to this problem, my guess is that's where you need to spend most of your time and effort. And time and effort, the currency for that in legal writing is words. So that's where you'll be spending a lot of your words. If it's really, really simple, easy to talk about and not particularly relevant, hardly any words. If it's super, super easy and not at all relevant, maybe no words at all. Okay, that's an approach I take, but think about, you don't have to do it that way, absolutely not, but just think about the way to do it. Plan. Plan, 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 plan. So, once you've actually done all of your planning, and once you've actually written it through, you will get to writing a conclusion. One of the criteria for this is, do you have a good conclusion? Does your conclusion follow on from what you've done earlier? So a conclusion, now you might not actually have it at the end as a conclusion. You might have an executive summary at the beginning which contains your conclusion. That's often a better way. Think about your reader. One of the things I know, and I mean, any of you who work in law firms will find this really surprising, but some lawyers are quite lazy. I know, go figure, I know they hide it well. One of the things I see happen often is that they'll read the executive summary or the conclusion. I know I've done it a million times. I'll have a quick look at what sources they looked at, and I'll read the conclusion, and it's got the sniff test. Does that make sense? Have they looked at the things I would have looked at? And does it sort of sound right? And if it's not controversial and there are no big dollars attached to it, they may not go any further. So make it easy for your reader by putting your big picture statement conclusion up front. Answer the questions. If you get asked specific questions, answer the specific questions. Does a couple of things. One is it will help you structure. You've been asked specific questions, so checking off that you've actually answered them really helps. It's respectful to the person who's asked you a question. It's actually quite disrespectful, particularly to clients, if a client asks you, is this a tree? And you give them 5,000 words on the evolution of forestry. They're like, you know, actually, I just want to know, is this a tree or a shrub? Like, it's just, they feel like you think they're stupid, or they think that their question isn't the right question. So even when they don't ask the right question, and they won't always, being able to answer the question they've asked in a respectful way, but still solve the problem is an important skill. Just summarise, your conclusion is you don't need to reiterate your answer or your analysis, but it needs to be linked. Don't introduce anything new at this stage. So if you're talking plumbing, 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 and I conclude garden supplies, it makes no sense, right? Makes absolutely no sense at all. If you are introducing something new in your conclusion and you feel your conclusion makes no sense without that new thing, go back and look at your analysis, because clearly there's some sort of gap there. If you've got mini conclusions, link them to the issues. So if issue number 1 was he wearing a hard hat? Conclude, no, he wasn't wearing a hard hat. The answer to issue 1 is no, or something like that. You don't have to be as bleak as that, but you understand what I mean. Remember too, in the real world, the conclusion is often used as the summary bit is often used for other purposes as well. Might be put into the firm's knowledge management system, might be a way that when people are looking for advices on whatever it is that you're advising on, keywords are taken from that by the library or the knowledge management staff as well. If you are referring to legislation at any point, it is a good idea to set out verbatim, so copy it out exactly, the relevant provisions in a way that flows in your memo. Remember, you have to do this with AGLC 3, which means if you've got a quote of more than 3 lines, you have to indent it in a separate paragraph in slightly smaller font and not use quotation marks and do all of that guff that we all agree is ridiculous, but you have to do it. So do it. If the legislation that you're dealing with is longer than a page, maybe you want to attach it to the back. Spoiler alert here, if you think you need to give me more than a page in legislation in relation to this answer to this problem, I think you want to actually rethink it and see if you can find the really, really relevant bit and quote it, because particularly with this problem, I suspect you might be on the wrong track. But think about your reader. Make it easy for your reader to find that. This is really, it's getting older and older. In the real world, you would include a hyperlink so that they can jump back to find what they're finding. So the discussion or analysis part, this is where you need to describe the relevant law and use the commentary on the law as well. So think about how the law applies to your particular issue and make sure that it counts. So you've got to predict how a court would likely resolve the issue. And this is a really important word here, likely. Well, sorry. Go back the other way, jumping too quickly. Likely. Okay, unless you are writing this with Justice Keifel on your left-hand side and I'd say 4 other High Court judges on your right, you do not know what the outcome will be. You can have a pretty damn fine idea, but you do not know. Okay, law is not science, it's not physics, it doesn't work the same way every time. So be careful about being too definitive. What is also really important is that application to the specific facts that you have to hand. So again, as you read each of your paragraphs, if your paragraphs are just general statements about how the law of offer and acceptance works, keep thinking about how can you tie it back to the problem and ensure that it's relevant. What you're ultimately trying to do is ensure that your reader can assess how similar, different or applicable cases that you're using are to your facts. So if they're not even close, don't pretend that they're close. Just support, say the principle of law is X and provide the citation. But if you are recognising that there are a set of facts here that are similar to a case that you've found, then talk about the similarities and talk about how the facts might be distinguished or why you can see the similarities and why you think this case is of particular relevance. Also, go with the leading cases, just, you know, as an approach. Think about citing cases in a similar way to how you might have thought about providing supporting evidence when you are writing an academic analysis piece. Now, if you come from a science background, we know that primary data trumps secondary data, right? That the primary data, our actual experiment results, are generally of higher probative value than some academic article. But an academic article, a peer-reviewed meta-study of 57 different similar experiments that got different results to you might trump backwards, right? So what we're looking for here is think of the cases as primary data. But a case in VCAT is nothing like a full decision of the High Court. And an academic journal article or an encyclopedia that deals with the High Court or talks about the High Court cases is probably going to have more value if it's peer-reviewed, again, than an unreported magistrate's court decision or a VCAT or a tribunal decision. Okay, so think about what's the best evidence to support what I'm saying. Now, if you make a statement of fact, you don't have to cite the made-up facts for this particular event. But if you cite a fact that's not something that's been given to you as part of the problem, so, for example, I don't know, you might find some data on the actual price of jousting sticks you know, what the market for jousting sticks has been over a period of time. If you think that that's relevant, if you're going to make a statement about the price of jousting sticks, support it with data. Okay? Make sure that you've got some study or some economics to deal with that. If you make a statement about what the law is also a fact, right? So what the law is or what a principle is, every statement of fact needs to be supported by evidence. So a statement about what an offer rule is or what acceptance is or whether an objective test is used, all of those things are statements of what the law is. You want to support it with a case or legislation. You want to pick a leading case. You want to pick the most relevant. If you can't find it, and there are some things, this is also old and some things go without saying, use your textbook. Definitely use the textbook or a journal article over Kath said it in class. Okay? On the pecking order of what to use as citation support, my slides and my voice are below your mum. Okay? So I will probably pay, I asked my mum as a footnote over a reference to my slides. Just saying. In fact, I will pay my mum over that. And yeah, anyway. Okay. Part of being an ethical lawyer, one of the ethics requirements for all lawyers is we have to act in the best interests of our client, and we have to act in the best interests, well, we have to put our duty to the court even above that. So in any matter, our job is not to find an argument, no matter how spurious, that puts our client's interests first, even if it's completely unrealistic. Our job is to assess the law objectively and to give our client a realistic expectation of what the answer to their question will be. Now, they then make a decision about whether they want to fight or not, and then our job is to fight as hard as we can within the bounds of honesty, even if we've already advised them that we think they haven't got high chances of winning. But we have to look at both sides. So don't ignore or conceal anything that's uncertain or ambiguous or that could negatively affect your client. Even our imagined clients, we all tend to fall in love with them. We want our client to be on the side of right. Our job is to advise, so we need to take that very seriously. So give good news and the bad news comes out of your research advice. Give it cleanly and clearly. So, and give an opinion on both the strengths and weaknesses of your position. I want you to take a side, but that doesn't mean that it's a side at all costs. You need to show your reasoning. You know, back in Year 10 maths when you had to show your working out, you have to show your working out. Going straight to the conclusion doesn't help me understand whether you understand what we're doing. Doesn't help Dennis either. Make some recommendations. What should Dennis do next? Should he call the client? Should he write to the client? Should he recommend that they immediately do blah, blah, blah? Should he start drafting documents to take an action against somebody? What should he do next? What happens next? I think all these other things I have spoken about, but you'll have this slide pack so you can have a look. Okay, in the real world, if time, logistical or other practical constraints force you to rely solely on the textbook or secondary sources, say so. I will not be amused by a paragraph that says, Dennis, as you know, I've been playing bridge all week and I'm in a pole dancing championship, so I haven't really had time to do the work on this one, so here's a copy of chapter 3 of the textbook. It will amuse me. I will probably tell everybody about it, but it's not going to get you through. Where it might work in the real world, when I give you something at 8 o'clock at night and need it by 8 o'clock the next morning, it might be, sorry, best I could do is come up with the textbook. Off you go. That happens. make sure that you identify, this actually links in with assumptions, anything pertinent missing information. So if you've assumed, going back to Leia Organa's red dress, that is really important, you might need to want to make sure that that missing piece of information, like whether she had red boots that went with it or not, you specifically asked. The other thing you need to do here is look at the assessment criteria and make sure you've answered the question. Before you submit it, get the assessment criteria out and check, have you done all those things? Plus, have you answered the question? This is a little bit more real-worldy because in the real world, if you give me a reference list, I want it to be useful to me, so I usually don't care about it being organised the way that AGLC 3 tells you to organise it. I want it organised in ways that are going to help me move the research forward. But here, you do need to have a reference list and you need to do it with AGLC 3. So have a look at the formatting. Look at the headings. So section A, section B, section C, make sure that you use the headings appropriately. Remember that the way you cite some things in AGLC 3 in the reference list is different from how you put them in the footnotes. So just check that level of detail. Yeah, so use AGLC 3. If you haven't already played with it, the library has quite a good citator tool, so it's called Easy Cite. Basically, you can have a look at different ways to plug in different things. Most of the universities have citation tools. They're similar but different. Have a look at them. My top tech tip for dealing with it is go to the Melbourne Uni website, bring up AGLC 3. I know you've got the little blue books, but bring it up as the PDF. Your best friend is Control F, find, and then have a look. I need to put a footnote in. Why don't I just go and read that? All of you are new to it, just read the whole thing. So there are some things that I find myself giving comments on all the time. For example, footnotes, other than in one exception, the M dash, always appear on the outside of punctuation marks. So full stop, footnote, reference, not reference, full stop. Okay? Little things like that make the difference. If you're kind of interested in it, and well, I know nobody's interested in it, that's a ridiculous thing to say, but you know, if you're wondering, should I be asking questions about this, look at your textbook. Your textbook uses AGLC 3, right? So look at the way that they put the case names in text and then in the footnotes. When they use IBID and above N and those kind of things, look at it, because if yours looks different from that, just guessing, but chances are they're right and you're wrong. I could be wrong, and I'd love you to point it out. The reality is both of you know more about it and care more about it than I do. So it's a terrible thing. It just breaks my heart when I can't put work, particularly in that writing section, which is well written, and I can't put it into the distinction or high distinction category because AGLC 3 is all over the place. The other thing for those of you who come from an APA or a Harvard referencing background, you know the brackets with the year? Never, ever, ever by themselves, okay? So if you've got the case name, brackets with a year or square brackets, round bracket, doesn't matter, then you're going to have the whole rest of the citation in the text. If you only got the case name, then the year goes into the footnotes. I regularly see case name and the year, and that's just not how it's done. I know. Go figure. Appendices, they're optional, they're rare for something like this. They're for long bits of information that your boss needs to see. So that page of legislation we talked about earlier, but organise them, make it easy for your boss. Languages, verb tenses. I get tense when we use the wrong tenses. If we're talking about things that have happened in the past, like facts or decisions that have been made by the courts, we talk about them in the past tense. If we're talking about what the law is now, we talk about it in the present tense. And if we're talking about things that you should do in the future and the recommendations you're making, then you talk about those prospectively or in the future tense. Language. You're expressing a considered conclusion. You are solving a complex problem here. You're using logic and reason to do so. So I think, well, maybe it's probably will work in some context. I feel they're not really the right language to use. If you don't know something, say so. You might need to say you're still investigating or that you need to get further information in the real world. Again, it's not going to curry favour with me saying a memo that goes, "Dear Dennis, thanks for the facts. Hope you had a nice time fishing. Really haven't had time to get to this, but I'm sure it's a legal problem and the vibe will work itself out. I'll keep investigating and I'll get back to you when I've got a minute." That's not going to work. At the same time, if you do think you need more information, you might include a section in there that says, "Dennis, next time you talk to Steve, could you please ask him blah, blah, blah. I need that information in order to make a really clear decision about whether it's an offer or a counter offer. Based on the information that I have now and the assumptions that I've listed in paragraph X, I think it's more likely to be a counter offer. But if I'm incorrect, it might even be a supply of information, blah, blah, blah." See what I mean? Use plain language. I'm not going to read this out loud. I like Mr. Homer E. Meyer Jr.'s quote because I think in some ways it does exactly the opposite of what it's recommending. It's quite flowery in language. But think about the style that you write in. Some of you will really want to sound clever, and many of you think to do that you need to use passive language, big words, long paragraphs. Often the flowery language and the use of Latin actually just shows me that you don't really understand what you're talking about. So we used to joke in the profession, a boss of mine used to say, the only time you ever use Latin is when the concept is so abundantly clear it would be hard to charge somebody for the advice. So let's work on the basis that we're, not worried about charging for the advice even when it's in clear language. So citations, I've just been talking about that. Have a look at this. Think about your reader. So it's actually rarely useful to start a sentence by telling me what case you're talking about. I'm not interested at this stage in the cases. This is not a case analysis piece. I'm interested in how the law applies to my problem. So really give me the information I need first and then support it either in a footnote or in text, depending on how it reads best towards the end. Avoid string citations. AGLC 3 doesn't like, sometimes I get 15 footnotes in a row. One footnote with a whole, with the citations in it is great. Mostly if you give me 20 cases or 10 cases or 8 cases to support something, I will think you don't know which one's important. Or you're trying to show off. But if you find, I only need one, but I need one, and I need the best one. No one reads them, particularly when they're italicised, which they have to be. They're hard to read. So think about your reader. Footnotes. Lawyers love footnotes. Lots of you guys love footnotes too. It's sort of because footnotes don't count in the word limit. So often you use them to hedge your bets. One of the bets you should be thinking about is how much you're going to piss me off. No, I don't piss off easy actually. So sometimes you'll want to put something interesting in there, and you'll see that all the time. Even in your textbook, there'll be sort of little run-off bits of stuff that's not particularly relevant. They'll just be thrown into the footnotes. Try and avoid that. If it's essential to understanding the text or understanding your answer, it needs to be in the body. If something that's in a footnote is necessary for your conclusion, don't put in a footnote, put it in your actual argument, because you've got to work on the basis that people will only read the footnotes if they've got time or they're interested in delving into the next step. So you've made a statement of the law, you've supported it with a particular case. My next step might be to have a look at that case to make sure, because I might not, think you have the right approach, or I might have thought about it differently or something. Try and limit the number of quotations you use too. Really, the only time you really want to quote something is if it's not possible to put it in a better way. Review the assessment criteria. I know I said that before, I'm going to say it again, because the assessment criteria is, surprise, surprise, the criteria on which you are assessed. And so if you don't do the stuff that you're assessed on, it's really hard for me to give you the marks. Where do you find it? Basically, this is what it is. For those of you who are doing the discussion board tasks, what do you know? For the problem task, it's exactly the same criteria. And so by tomorrow, everyone in OUA at least will have got some feedback from me on their first task, which, by the way, was done extraordinarily well. I was really pleased. And there are 4 or 5 in this class who've done them as well, and I'll try and get those out pretty quickly as well so you can see. Basically, headline issues, 20% of your mark goes to how well you've identified the issues. 15 goes to how well you've identified the applicable rules. 30% goes to how well you've applied those rules to these facts. So again, if by some stretch of the imagination, and looking at you, I can't imagine this would happen, but just say you don't actually identify all of the relevant rules, it's going to be really hard to do well here. Okay, because you can't apply, I can't give you marks for applying rules that you haven't applied. You need to come, oh sorry, that's above, well actually it falls through into the conclusion as well. So the conclusion, if you haven't done the analysis, then your conclusion may well be very limited. But again, so 15% based on your conclusion, and 20% goes to presentation and referencing, how well you write, how well you structure, etc. In the Canvas, I have provided this much more detailed version of the rubric for this assignment. I haven't done them for the one-by-one ones, the little 5%ers for OUA, because there's just, every one of them will be slightly different. But I've got a version of this for each of the 2 big assignments. So basically on the, I've only got 1 page of it here, but on this side, basically bullets out the kinds of things that we're looking for under each of those categories. And this shows what a fail looks like, what a pass looks like, what a credit, distinction or a high distinction looks like. They tend to be a bit cumulative, like so a credit is a pass with some extra sauce. A distinction is a credit with some spicy sauce, and a high distinction really distinguishes itself, stands out from the crowd. It's like, a 3-hat sauce. It's a Jew. J-U-S, just in case that got taken the wrong way. The next thing that you have to do is answer the question, all right? You have to answer the question. And by that I mean you have to answer the question. It's really important that you answer the question. And I will leave you with Harrison Ford. To end that, it's really important that you answer the question. Could I be any clearer? Questions, concerns, frustrations. All right. This is not hard, by the way. Ellie. It's gone. Don't you hate that when you're just asked to...
I'm thinking endnotes, footnotes.
Footnotes and a reference list?
Yes.
Yes, Dennis has specifically asked you for a reference list, and the reference list needs to be formatted AGLC style. So I have some words in the PowerPoint that specifically refer to ways that you might do a reference list out in the real world, but we are not in the real world. We are in academic land, and you need to do it AGLC style. Yep. But I would always include a reference list with a research piece, because it tells, even if you haven't specifically referred to something, your boss wants to know what you've looked at. So if you've looked at something and not referred to it, then they know that you didn't find anything useful there. And I know when I'm doing it, I'm looking at what people, because I know where I would start, but I don't know the answer to the question. So if you've started the same place I would have started and finished somewhere different, at least I know the journey is something I would trust. That's in the real world. In this world, I actually have a pretty strong view on what the answer is already. Doesn't mean I can't be convinced otherwise. And I regularly give HDs to people who get a completely different answer from me, because criteria. Any more questions? Edwina.
Yes. Some lecturers want us to define things to memos to council, but when you're writing a memo to council, do you want us to define it or just a letter to clients?
No, well, this is not to the client. This is a memo addressed to Dennis Denuto, who is your boss.
You don't need to define things
No.
for him.
Well, unless you think he needs a definition in it. So sorry, I could have read your question or listened to your question a couple of ways. So one is memos to council, you might actually set out and use, it's quite common in legal writing to use a term over and over again.
Yeah.
And so if that's your style of writing and it works for you, it might be, for example, you might talk about, there are two different problems, and you might call them problem A and problem 2. I don't know, because you're a lunatic. But all the way through then you might say, in this memo, when I refer to problem A, I'm talking about blah, blah, blah. And references to problem 2 are blah, blah, blah. I'm doing it that way so that you don't use problem A and problem B. And then when I go back to you afterwards and say, how is that helpful to your reader? You say, you told us to do that in class. Like, I don't want to tell you how to do it. I'm just trying to give you some examples.